Good afternoon, everybody. Thank you ever so much for joining us. My name is Mike Fox. I am the Head of Communications for the OEP, and I'll be taking you through today's event, this afternoon's event. A really exciting time for the OEP. This week we now have our remit in Northern Ireland confirmed, and we wanted to get some time in with as many people as possible, just to start introducing where we are with the OEP in terms of the establishment, but also very importantly, we are currently out for consultation on our draft strategy and enforcement policy, and we really wanted to introduce that to people and get some opportunities for people to speak to us about it, with a view of taking part in the consultation, which runs up until March the 22nd. So we've got around 4 weeks or so for people to take part in that. I'll be honest, this is the first time we've used this particular platform, Teams live event, so we're kind of learning as we go. So bear with us. There will be a couple of presentations to introduce various parts of the strategy and the enforcement policy, and also we do intend to try and get some opportunities for questions and answers as we go as well, or maybe, sorry, a session at the end for questions. The first person I'm going to hand you over to is the OEP's Interim Chief Executive, Natalie, and she'll give you a bit of the context, a bit of an update on where we are, and just start talking to you about the strategy.
Thank you, Mike. So please do bear with us today as we trial out this new platform. Hopefully things will all go smoothly, but if they don't, I'm sure you'll be understanding. So I just wanted to say, firstly, I'm absolutely delighted to be here to speak with you today, our very first OEP-led Northern Ireland stakeholder event. And we're here to talk about our strategy and enforcement policy. And I've got a number of members of the team here at the OEP to talk you through different components of that in some detail. So firstly, I'm really pleased that following the decision from the Northern Ireland Assembly giving their approval, our functions will commence in Northern Ireland next Monday, 28th of February. That is excellent news. We are delighted at the OEP to have that confirmed, and it means we can complete and finalise our strategy to cover both Northern Ireland and England. I'd like to thank the Northern Ireland Executive and the Assembly for the trust they've placed in us. We look forward to getting on with the job. We're very confident we can make a positive difference for Northern Ireland's environment and its people. And the important part of that is that you're here today to help us get that right. The decision by the Assembly to confirm our role in Northern Ireland is a significant step for environmental improvement and protection, and a welcome new responsibility for us at the OEP. Before I talk about our establishment and our strategy in a bit more detail, I understand that you may have some questions regarding the appointment of the Northern Ireland Non-Executive Director at the OEP. What I can tell you about that is that the appointment process is very much underway. Interviews have been conducted and we are hopeful and indeed expect that this process will be completed very soon, and DAERA will then be able to appoint the successful candidate to our board. There is, of course, work for us to do to make sure all the correct resources and arrangements are in place for us to take up this new responsibility, and we are working with DAERA and other colleagues and stakeholders to get this work done as soon as we can. So the information we'd like to give you today about our strategy isn't entirely specific to Northern Ireland. Rather, it's an OEP specific strategy, as we have remit in both England and Northern Ireland and very similar functions. Our strategy and enforcement policies will apply in England and Northern Ireland. Of course, we'll want to understand any unique issues or circumstances in Northern Ireland so that we can take account of these in finalising our strategy. And it's key that we hear your views on those issues. We also want to know what you think of the strategy more generally. So back to the OEP. Well, we're a brand new public body and we have a critical role to play. I'd like to thank all of our stakeholders in our community, Parliament, the Northern Ireland Assembly and Government who've championed and enabled the creation of the OEP. Many of you have been on the journey with us, and I'd like to thank you again for the support and the insight that you've given us so far. Please keep doing that, and for your ongoing support, time and energy in helping us get up and onto our feet. Some of you are here with us today, and I hope you continue with us as we move forward into this exciting new phase. Our mission to protect and improve the environment by holding government and other public authorities to account is both important and demanding. We need to get it right, and we are now ready to begin our work in earnest. We could move on to the next slide, please. So this is just a little flavour, and I'm sure will be familiar to many of you, about the OEP's toolkit. We've got a broad toolkit available to help us do our work. So we will scrutinise EIPs, environmental improvement plans, in England and Northern Ireland. We'll monitor and report on the implementation of environmental law. We'll advise government on proposed changes to the law, other matters related to the natural environment. And we will investigate suspected failures to comply with environmental law by public authorities. We will enforce compliance where we need to. Our toolkit empowers us to undertake a breadth of work, but these activities need to be targeted and coordinated if they are to drive genuinely positive change. And this is where our strategy is so important. Can we move on to the next slide, please? So our proposed strategy, and it is out for consultation, outlines the approach that we think will work best. It fleshes out our ambition about how we can make a significant contribution. We set out clearly our core aim to focus specifically on those areas where our actions will have the greatest positive impact. We launched this strategy for consultation with more than half of our initial staff recruitment complete. We start as an organisation which will have 53 staff in this, our initial phase. We expect to recruit some additional resources and expertise to accommodate the extension of our remit and functions into Northern Ireland as soon as we are able to do so. But we must prioritise carefully as we identify the issues on which we will act, as well as the approaches we take, drawing on that toolkit that I just outlined. We have committed to do that transparently, not least because in making these choices, there will be matters that we choose not to prioritise, and we know already that those choices will not be easy ones. We set out in our proposed strategy how we intend to make those choices and the factors that we will take into account so that our decisions can be well understood. Purposeful prioritisation will also ensure that we make effective use of public money. We're looking forward to a full review of our operations and resourcing later this year, when the evidence from our first months of full operation can support a much better informed understanding of our resourcing needs for the future. The Environment Act requires us to report to Parliament and the Northern Ireland Assembly on the sufficiency of our resources. We will be clear on the difference our resources allow us to make. Key to many of the approaches in this strategy are appropriate, productive relationships with other organisations, including those that we oversee. We've already begun to work with a wide range of stakeholders. We are committed to be a learning and listening organisation, consciously working to bring diversity of perspective, thought and challenge to our work. We recognise the value to us of the technical expertise, insight and on-the-ground experience of others. We aim to earn our authority so that our voice is one that is heard, respected and can therefore influence better outcomes for the environment and people's health and well-being. We aim to be a trusted voice with a commitment to evidence and sound analysis. As I said before, I'm so delighted with the support we've had from such a wide range of stakeholders to date. We have listened carefully to their advice, drawn on their insights, and I hope that many of you can see that reflected in our proposals today. The uncertainty around our remit has inevitably meant that we've not previously been able to engage with stakeholders interested in specific Northern Ireland issues to the same degree, and I'm very pleased that we can now do that. I hope that you will read our consultation with interest and respond with your views. As I said at the start, we need to get this right and you can help us do that. I'm sure you will have questions regarding how we operate in Northern Ireland, for example, whether we will have staff based in Northern Ireland or whether we will have a Northern Ireland office. We are thinking through what the best approach to our recruitment and employment will be, following confirmation of our Northern Ireland remit on Tuesday. The intent is for there to be one OEP covering England and Northern Ireland, not two separate entities. For our Northern Ireland activities, we want to draw on the full weight of OEP expertise. At the same time, we recognise that we must be able to understand and attend to Northern Ireland's unique issues and circumstances and a visible and proactive presence, however that is best achieved. We therefore need to make sure we bring in the expertise and knowledge for us to be effective, including local and specialist knowledge. These are key questions for us to answer, but as it's early days, we don't have the answers just yet. We have had a good discussion with our executive committee just this morning, and we will be speaking to our board members next month. We hope that our Northern Ireland non-executive director will have been appointed by then and can play an active part. Finally, I wanted to say that it has been a privilege to lead the OEP into its first operational year. As we have formed over the last few months, the calibre and expertise of our board members and both our interim and permanent staff has enabled us to move forward at a considerable pace. I'm going to be handing over shortly to a number of our team to talk you through the detail of our proposals. I'm really glad that they're here today. Every single one of them has played an important role in developing the strategy we're going to talk to you about, and they will have an ongoing role in relation to different components of it as we go forward. Together, we are committed to developing the OEP to be the very best it can be. I look forward to working with them and with you to deliver this strategy for the lasting benefit of people and the environment. Thank you.
Thank you so much, Natalie, for setting the scene for us. What we're going to do now is go through 4 or 5 presentations, looking at more in depth at some of the different aspects of the strategy and the enforcement policy. One thing I will say just before we move on is it would be remiss of me not to tell you how you can take part in the consultation. So the best place, simplest place is the OEP website, www.theoep.org.uk, and there's a live consultation page there. If you have any sort of need to get hold of us or ask us any questions around that, there is an email address which is consultations@theoep.org.uk. The first person I'm going to hand over to now is my colleague Andy Lester, who is Head of Business Strategy and Planning, and he will be talking to you about the OEP's strategic objectives and also the approach to prioritisation.
Good afternoon, everybody, and thank you again for joining us today. So firstly, I'm going to talk about our strategic objectives, as Mike said. We have a principal objective set out in the Environment Act, and that is to contribute to environmental protection and improvement in the natural environment. And our 4 strategic objectives set out how we aim to achieve that and make that contribution. We've set these 4 objectives out for consultation, along with the approaches we describe for how we'll aim to achieve them. And I'll introduce you to them now before some of my colleagues go into the detail of how we propose to do our work. So if we could move to the next slide. So we will strive for sustained environmental improvement. We know that government is uniquely placed to protect and improve the environment, not least because ambitious plans, goals and targets are fundamental to environmental protection and improvement. Our aim is that government is held to account for delivery of these plans, goals and targets. We'll work towards that primarily through our scrutiny of the environmental improvement plans in England and Northern Ireland, and also in England on our scrutiny of statutory targets. You'll hear more about how we'll do that later, but we'll critically assess, report and advise on the development and delivery of these measures, and in doing that hold the government to account for their ambition, progress and delivery. We'll also support this objective through our other work. For example, we'll make recommendations for how changes to the law or its implementation could help deliver government's plans by challenging failures to comply with the law that undermine environmental improvement. We also strive for better environmental law, which is better implemented. Our aim here is that the environment is protected and improved, and people are protected from the effects of human activity on the natural environment through better design and implementation of environmental laws. We'll work towards this objective mainly through our work scrutinising environmental law and providing advice. And again, you'll hear more about our approach to that work in a minute. In pursuing this objective, we aim to improve the effectiveness of existing environmental laws and support the good design and implementation of new ones. Our approach looks at all stages of the law, its design and all relevant aspects of its implementation. Go on to the next slide, please. Thirdly, we strive for improved compliance with environmental law. Our objective is that environmental law can protect people and protect and improve the environment as was intended when the law was created. We expect government and public authorities to abide by the law so that this can happen. We'll work towards this objective by holding government and public authorities to account for compliance and challenging serious failures. Again, you'll hear more about our approach to enforcement later. We'll work strategically and aim for all our work to achieve wider and sustained benefits. Our approach to scrutiny of the law and work to improve environmental law may also help identify and challenge systemic issues of non-compliance and their root causes. Finally, our fourth objective is organisational excellence and influence. We believe the environment will be best served when we use our powers to their greatest effect, strategically, expertly and independently. Our objective is to be an organisation that does just that, and to be an effective and efficient part of the system, with the authority, relationships, expertise and voice to play our full part in environmental governance and stewardship. We set out some of the ways we're structured and will work to make the most of our resources, how we aim to develop and earn our authority and develop our voice, and use them both with purpose and wisely, so that when we say what needs to be said, others listen. We also set out how we will develop access to deep expertise and listen and engage with others. In our consultation, we seek views on these objectives and the approaches we set out to pursue them. We're really keen to hear what you have to say. But next, I'm going to speak about our approach to prioritisation. We know that how we prioritise will be material to how much we achieve. We're asking for views on the approach we've set out. We do have a wide remit. And as Natalie has said, we start as an organisation which will have 53 staff, with some more to come to accommodate the extension of our remit and functions to Northern Ireland. We'll not be able to do all that some people might wish of us, and nor can we tackle every problem. But where we choose to act, we'll act strategically, and we'll act with purpose, and we'll act to make a difference. We know it is critical to choose well. We propose to make those choices in a structured way, and to be transparent about how we prioritise, the things we do prioritise and those we don't. Our approach is built on 4 principles. The most important, and firstly, is that we'll prioritise by outcome, so by what makes the most difference as a whole. One of the things this means is that the amount we do in each of our functions will differ over time. Sometimes we might have more enforcement casework, at other times more scrutiny of environmental law. It'll depend where we judge we can make the most difference. Secondly, we know we'll need to make judgments to prioritise. We'll use the evidence available to us at the time we decide to make those judgments. And we'll do that by assessing 4 questions, which are on the next slide, actually, if you can move on. And those questions are, how large an effect could our action have? How much difference could we make? Secondly, how likely is it our ability to have that effect? And we know that the environment is a complex system and the effect of our actions will not always be certain. So across all our work, we will try and balance where we judge we might have greatest effect and where we can be most confident of a positive impact, with the aim that we achieve the most difference overall. Sometimes we know we'll be the only organisation able to act, and at other times we might judge others a better place to make a difference. We'll judge these things in this third question of what is the strategic fit with the OEP, alongside making judgments about the broad portfolio we've spoken of, and working to make sure we have balance across our work, where we can and should, including balance across our remits in England and Northern Ireland. Finally, we'll make judgments that we can do it, and we have access to the resources and expertise to make a difference. We know this prioritisation approach is really important to our success, and we ask your views on this approach in the consultation. I'll now pass back to Mike to introduce our next speakers. He'll go into some of this detail.
Thank you so much, Andy, and clearly being able to clearly set out what it is we're trying to achieve and how we're going to make some of the decisions that we're going to have to make is a crucial part of that strategy. And as Andy said there, we really do genuinely value the responses that we get and the input we get from our stakeholders. It is so valuable, and we are so determined to act on that and help it make our strategy the final version the best it can be. The next topic we're going to speak about is working with others, and I'm going to hand over to my colleague Tim Graham, whose title is Head of Natural Science and Analysis. Put my teeth back in, and I'll leave you in Tim's capable hands.
Thank you, Mike, and good afternoon. So I'm going to be briefly covering working with others, and while this is a sort of a short section, it's no less important than the other presentations you've received this afternoon. The natural environment is complex and diverse, and the range of organisations and perspectives are much the same. So the OEP cannot act effectively in a vacuum. Making the most difference will require our ways of working to be really clear, and obviously how we're working with others is going to be hugely important to that. So if you could move on to the next slide, please. So obviously our external relationships are going to be hugely important, and these are going to be founded on understanding, trust and respect, and as I've just mentioned, it's going to be critical to our success. So how we work with others is also going to inform our exploration of evidence. It's going to be necessary to take a wide view of evidence, just like such a broad array of environmental issues. And so a wide view of evidence that we're actually going to be seeking and using is going to end up requiring a broad range of disciplines, a broad range of access to expertise to inform our approach. And obviously that's going to end up informing our ways of cooperating, communicating and collaborating with a wide range of public authorities and others across the sector. We're going to be communicating openly where appropriate, and it's going to be important to note that we will guard our independence of judgment and action where there are risks of conflict. If you could move on to the next slide, please. We're going to be drawing on and respecting the expertise of specialist bodies, and this is going to be a very important way of working that we're starting to actually form our more detailed approach. Our functions may overlap, and so written agreements such as MOUs may be appropriate. And obviously we're also going to be thinking in terms of Northern Ireland about the fact that there's transboundary potential for issues in the environment, and while we are developing our work across boundaries for England with our sister organisations, there's no equivalent organisation in the Republic of Ireland, and so it will require us to explore the most effective ways to consider the wider environment context and transboundary issues in terms of how we're choosing to implement our functions, and that'll be something that will be developed as we move forward. And importantly, it is crucial that we point out that there's a duty of cooperation in terms of public authorities providing us with assistance as we fulfil our role to protect and improve the environment. And that is why this is underpinned in law, and so the Environment Act creates a duty on public authorities to cooperate us and provide reasonable assistance, and that's going to be crucial as we move forward to ensure our work in environmental protection. So thank you, and I'll hand you back to Mike's capable hands.
Thank you ever so much, Tim. And clearly, as you said there in your piece, the way we work with others just is fundamentally important and underpins everything that we do and everything that we will achieve. So please be assured that we are absolutely committed to getting those relationships right and investing the time and the energy into working with others in the right way. I should just say at this point, I mentioned earlier that we are hoping to take questions, and I think you should be able to see a little speech bubble with a question mark in, so that's your opportunity to submit questions to us, and we will consider those sort of when we finish the other presentations. Okie doke. The next topic we're going to cover now is complaints. Obviously, one of our more public facing functions, one that gets a lot of interest, and we know that we have to explain what our approach, what our complaints policy and process is for people. So I think this is a really useful session, and I'm going to hand over to my colleague Grant Daly, who's our Principal Complaints Manager, to take you through this section. Thank you.
Thank you, Mike, and thank you all for attending. Good afternoon. My name is Grant Daly, and I am the Principal Complaints Manager for the OEP. In this segment, I'll be explaining a bit more about the OEP's complaint system. I'll be outlining the formalities behind submitting a complaint. I'll be explaining why complaints are important to the OEP and how the complaint system integrates into the wider OEP function. I'll also be talking about the complaints that we can consider, as well as the matters that the OEP is unable to assist with. In addition to this, I'll be touching on our commitments to those who submit a complaint to us. As I'm sure that many of you are aware, the OEP has a particular purpose, and our remit for considering complaints is outlined in very specific detail within the law. In specific terms, we are able to consider complaints providing they relate to an alleged failure to comply with environmental law, and that failure relates to England, a reserved matter, or from the 28th of February, a matter relating to Northern Ireland. All complaints that are submitted to the OEP must relate to a public authority. And on the flip side of this, we are not able to consider complaints that have been submitted themselves by a public authority. It is not the role of the OEP to mediate in disputes between public authorities. Furthermore, all complaints should have exhausted local resolution before the OEP is able to consider them further. And by this, I mean that the relevant public authority should have had an opportunity to consider and respond to the matter before we can take it on board. In addition to this, there is an ordinary expectation outlined within the law that complaints should be submitted within the specified time limit of either 1 year of the event taking place or 3 months after the end of local resolution, whichever is later. The OEP does have the discretion to waive the time limit, but can only do so in very exceptional circumstances. If a member of the public has a concern that meets the outlined criteria, we would invite them to consider the information on our website and submit a complaints form. On receipt of this, we would consider the matter in more detail and would make a decision about how to proceed. So in discussing the OEP's complaint system, it is important to remember that the complaints process is one element of a much wider suite of functions that are designed to facilitate the OEP's objectives. In rationalising the system, I often find it helpful to use the analogy of a mountain stream, with complaints information flowing downhill to the tributaries that are the OEP's functions and objectives. These tributaries themselves would in turn combine together to create the river that is the OEP's principal objective of contributing to environmental protection and improving the natural environment. Given the OEP's specific objectives, the overriding aim of the complaints process is to provide a forum to enable members of the public to submit information to the OEP about alleged failures to comply with environmental law. As has been mentioned, the OEP is a small organisation with a large remit, and from a very pragmatic perspective, it simply would not be possible for us to be able to investigate every complaint that we receive. However, while investigations are an important component of the OEP toolkit, they are not the only reason why complaints are important. Often overlooked is the value that individual complaints and the accumulation of individual complaints brings us in terms of broadening our intelligence whilst identifying key systemic and thematic issues. By integrating the complaints process into the wider functions and through, using the analogy of the river, creating free-flowing information channels, we are in an opportune position to be able to facilitate the OEP's ability to be able to see the big picture, thereby furthering the OEP's mission of protecting and improving the environment by holding public authorities to account. It is for this reason why I always emphasise the importance of complaints, even if it is not possible for us to take the matter to further investigation. As has been alluded to, the OEP has a very particular purpose, and our remit to consider complaints is outlined in specific detail within the Environment Act. In broad terms, we can consider matters related to a suspected failure to comply with environmental law, with the Environment Act defining environmental law as any provision other than the devolved provisions in Scotland or Wales, to the extent that it is mainly concerned with environmental protection. What might be less clear, and what I thought it might be helpful for me to clarify at this point, are the matters that we are unable to assist with. The most obvious group of matters that we are unable to assist with are those that are described as being excluded matters within the Environment Act. This includes matters related to the armed forces and national security. It includes matters related to taxation, spending, and the allocation of government resources. It also includes matters relating to disclosure of or access to information. For various reasons, the legislation specifically prohibits us from considering these matters, and accordingly we are unable to take complaints of this nature further. Given the very particular purpose of the OEP, it is essential for the organisation to have substantial expertise and a thorough understanding of environmental law, as well as government policy and ambition. It is also necessary for us to have a developed knowledge as to the environmental matters that members of the public bring to our attention. However, whilst the OEP does have this expertise, we are unable to provide legal or other advice to individual complainants through the complaints process. Or alternatively, we're unable to advocate on their behalf. The OEP's objectives are strategic and balanced, and as such, it is essential for us to remain independent, impartial, and objective at all times. If we were to provide legal advice or advocate on behalf of complainants, we would risk the accusation of not being objective, and therefore the possible suggestion that we were not complying with our intended purpose. In a very similar vein, given the strategic aim of the OEP, we are unable to use the complaints process as a means of remedying personal injustice or providing individual redress. Whilst it may happen as we conduct our work, it is not the main aim of the process. I thought it might be helpful to end my segment by explaining a bit more about our commitments to those who submit complaints, as is outlined within our customer charter. While we won't be able to consider every complaint, it is our aim to make the complaints process as accessible and transparent as possible. And in view of this, those that complain to us can expect to be treated with courtesy and respect. They can expect to receive transparent service with forthcoming explanation as to our processes and decisions. They can expect to receive open and fair consideration, as well as to be kept updated on our progress with their complaints. In addition to this, they can expect our full commitment to deal with them impartially and without discrimination or prejudice. I hope this presentation has provided you with some further clarity as to the complaints process. Thank you for taking the time to listen, and I will now pass back to Mike.
Thank you, Grant, and that's a really comprehensive run through of the complaints process and our approach. As such an important part of our work, so thank you for doing that for us. The next section we're going to move on to, it's titled Scrutiny and Advice. A lot of work for the OEP there. It's sort of quite a meaty title to be covered in one fairly brief presentation. So what I would say is, again, what we're trying to do here, I guess, is inspire you to go and read the document thoroughly if you haven't already had a chance to do so, and just take that time to get to know what we're proposing and participate in the consultation. As I sort of recurring theme throughout this is just to encourage you to do that, because your contributions will just be so meaningful and so valuable to us. So for scrutiny and advice, I'm going to hand over to my colleague Emma Hawthorne, and I always trip over Emma's job title, so I'm going to look at it. It is Principal Monitoring, Environmental Law and Advice Manager. So over to Emma. Thank you very much.
Thank you, Mike. So as Natalie touched on, we have a range of functions, or our toolkit, provided by the Environment Act, and I'm now going to talk about our scrutiny and advice functions and how they help us deliver our strategic objectives. So firstly, we have a statutory duty to monitor and report on government's progress with their environmental improvement plans. So in England, this is the 25-year environment plan, and in Northern Ireland it will be the environment strategy, and there was a public consultation on this which just closed in January. So in England, government also has a duty to set legally binding targets by the end of October this year, and then we'll also monitor and report on the UK government's progress with these. So our strategic objective is for sustained environmental improvement, and whilst other functions will contribute to this objective, we'll mainly achieve it through our work holding government to account on progress with their environmental improvement plans and targets. So how we propose to do this is through our independent analyses, which will critically assess and report on what is being achieved, and importantly, where there are issues that need addressing. So alongside comprehensive monitoring of progress across the areas covered by and we'll publish our findings for Government, Parliament and the Northern Ireland Assembly and others to see and act upon. So our first actions will be Our first report on the UK government's progress with their 25-year environment plan will be published later this year, and in it we focus on the 6 building blocks that we believe are essential for a successful environmental improvement plan. And our intention is that our report informs the UK government's review of their 25-year environment plan, so that the revised plan is improved in terms of better governance and better monitoring, which will improve the prospects of success. And we'll also achieve this objective through our advice function. And we were pleased to be asked by DARA earlier this year to provide advice on their environment strategy, and will do so shortly. We'll also develop a research programme to identify critical gaps in evidence and understanding of the natural environment. And whilst we won't fill those gaps ourselves, we will undertake research to determine how they might be filled. And we'll work with others to stimulate activity to fill these gaps by those best placed to do this. We'll also develop expert and independent panels to support our work. So in this way, we aimed for sustained improvement in the natural environment through government's delivery of their plans and goals and compliance with targets. On to the next slide, please. Thank you. So moving on to our statutory duty to monitor the implementation of environmental law, we can report on any matter concerned with the implementation of environmental law at any time, and we must publish our reports and arrange for them to be laid before Parliament or the Northern Ireland Assembly as appropriate, and government must respond to our reports. So our strategic objective is for better environmental law, better implemented, and whilst our other functions will contribute to this objective, we'll mainly achieve it through our work scrutinising the implementation of environmental law. So moving on to how we'll do that, the design and implementation of environmental law are matters for government and other public authorities. So our approach therefore will be based on engagement and influence and providing independent analysis, advice and recommendations to those who design and implement environmental law. So we believe the implementation of law goes beyond its introduction and compliance to the wider context and framework in which the law is applied in practice. So resourcing, other laws and incentives, and the choices made in administering and enforcing the law can all work against outcomes being delivered effectively. Through our stakeholder engagement and management of information, we'll maintain an overview of the implementation of environmental law. And this is the intelligence that Grant referred to, where our broader oversight enables us to identify systemic or thematic issues. Each year we'll also target in-depth monitoring on a smaller number of environmental laws, and this will allow us to get to the root of how these laws are implemented, their effectiveness and what improvements might be made. We'll produce authoritative reports and recommendations from our studies. And finally, our first actions will be commencing our monitoring work. And in selecting those first priority subjects for scrutiny, we'll consult with our stakeholders, our practitioners, public authorities and others who implement the law or are affected by it. We'll determine how to monitor and record relevant information, including establishing and maintaining an overview of upcoming reviews and any proposed changes to environmental law. And again, touching on our advice function, we'll give targeted advice to government where we believe it will make the most difference. Our objective is for environmental law and its implementation to be well designed and delivered so that positive outcomes for the environment and people's health and well-being are achieved. We aim to increase the effectiveness of existing environmental laws and support the good design and implementation of new ones. So our consultation sets out our proposed approach to our scrutiny and advice functions and asks for your views, and we look forward to hearing what you think. Thank you. I shall now hand back to Mike to introduce the final presentation.
Thank you ever so much, Emma. And as I said, covered a lot of ground there. And again, just to once again reiterate the plea, please do go and have a look at the documents themselves and get that full picture understanding and let us know what you think. We have one more presentation for you before we move into the Q&A section. So the last topic we will be covering is enforcement. The draft enforcement policy is out for consultation as part of that strategy. obviously a lot of interest in that, and I would encourage you once again to make sure you've seen that and let us know again what you think. I'll be handing over to my colleague Hattie Owens, who is principal lawyer for this last presentation. Thank you very much.
Thank you very much, Mike, and hello to everybody out there. It's really great to have the opportunity to speak to you today. As Mike just said, as part of our consultation on our draft strategy, we are also consulting on our draft enforcement policy, which is contained within the strategy as an annex. And the enforcement policy is a really important piece of the OEP jigsaw. As we recognise in the draft policy, and as reflected by my colleagues from whom you've heard already today, enforcement is just one of our functions. It's a part of our wider toolkit, and we'll use it where it's the most appropriate tool for the job. So with that in mind, we can use our enforcement functions to hold public authorities to account in relation to their compliance with environmental law. If we move to the next slide, please. I can't see it changing, but there we go. No, spoke too soon. So as you can see there on the slide, in this draft version of our enforcement policy, we've explained how we intend to do this, and we look forward to your views on what we've set out. I'll use this time now to take you through some of the key aspects of the draft policy, but just to note that this overview doesn't cover all of the policy's content, so I'd encourage you to have a really good read through, especially before responding to the consultation. Now, when you take a look, you'll see that we have set out our proposed approach to how we'll use the powers and duties that make up our enforcement functions in order to further our principal objective. And as part of this, we've set out 3 general principles which will underpin all of the enforcement work that we do. The first of these principles is that public authorities must comply with the law. And whilst this might sound obvious, we think it's valuable to explicitly recognise it. This means that any failure to comply with environmental law by a public authority is potentially within the scope of our enforcement functions. Our second general principle is that enforcement activity should be targeted to where it's most needed. As you've already heard from Andy, we will need to prioritise our work. This is also the case in the context of our enforcement functions. We won't be able to pursue every matter that we could potentially take on. As part of our prioritisation, we'll consider where we could make the most difference, where we can have the greatest positive impact. This might include in relation to systemic issues or individual but related matters which taken together could give rise to serious damage. Our third general principle is that enforcement activity should take account of all of the relevant circumstances. Now, the relevant circumstances will vary from case to case, but we'll need to conduct our assessments on the evidence available to us at the time, and we'll need to exercise our professional and impartial judgment in considering that evidence. Our aim in using our enforcement functions is to identify, address, and importantly resolve issues of non-compliance with environmental law. We'll be proportionate in how we do this. For instance, we'll normally try to resolve matters through cooperation and dialogue with public authorities, but where we need to, will not be afraid to use our powers to take matters to court. Now, we have a range of powers and duties that make up our enforcement functions. This includes a suite of new powers specific to us. As Grant's already discussed, we can receive complaints from members of the public about potential failures to comply with environmental law. There's no charge for submitting a complaint to us, and we accept complaints submitted in a variety of ways. We can also conduct investigations into potential failures. As part of this, we can request information from public authorities to help us get a comprehensive understanding of the issue. If we conclude an investigation, where we decide not to take any further steps, we'll produce and usually publish an investigation report. This must set out our conclusions following the investigation, and if we have them, any recommendations that we'd like to make. Now, where we're satisfied on the balance of probabilities that a public authority has failed to comply with environmental law, we can give the public authority a decision notice. In this notice, we can set out the steps we think the authority ought to take in relation to the failure, for instance, to remedy the issue or to prevent its reoccurrence. Public authorities are obliged to respond to these decision notices, explaining whether or not they'll take the steps we recommended, as well as any additional steps that they might choose to take. And finally, where we need to, we can commence proceedings in the High Court through a new mechanism. In Northern Ireland, this new process is called a review application. And whilst a review application is based on the existing judicial review mechanism, there are some important and valuable differences. For instance, if the court finds against a public authority following a review application, the public authority must then publish a statement setting out the steps it intends to take in response. You can see this could be quite a useful mechanism for focusing attention and ensuring public authority engagement with the outcome of a review application. In England, there's a similar mechanism called environmental review. We can also take more conventional actions outside of our bespoke procedures. This includes launching judicial review proceedings in urgent cases, and we can apply to intervene in other parties' cases where we think that we could be of assistance to the court. A draft enforcement policy also describes the decision-making framework that we intend to use to make sure that we're being as consistent as we can in exercising our enforcement functions. In setting this out, we've explained how we intend to approach the assessment of seriousness. Now, as some of you may be familiar with, seriousness is a really important threshold for us in being able to take enforcement action. If we want to launch an investigation, if we want to request information from a public authority, if we want to take a public authority to court, we must consider that the potential failure to comply with environmental law is serious. Our proposal is that determinations of seriousness will be rooted in a factor-based assessment. And so to this end, we've set out a number of factors we think will be relevant in assessing whether or not a failure is serious. These include things like whether the conduct raises any points of law of general public importance, or are there wider implications, is there potential precedent-setting value here, or would broader legal clarification be useful across the board? Other factors include the frequency of the potential failure over time, including any cumulative impacts, and also the behaviour of the public authority in question. Have they acted deliberately, recklessly or negligently? Have they ignored previous warnings or concerns raised about the issue? In addition, in cases where we think that we might need to take urgent action, we need to consider the likelihood that without our urgent judicial review application, serious damage to the environment or to people's health would result. Again, we've set out examples of factors that we think go to the seriousness of potential damage. This includes, for instance, the nature of the harm, taking into account the particular characteristics of the people or the environmental features concerned, and the degree of the harm. How severe is it? What's its extent? Also, any wider issues, such as any indication of a more widespread or systemic problem of which we should be aware. Now, after considering the factors that are relevant, we'll make an overall appraisal of seriousness based on our independent professional judgment. We would not normally expect to have to undertake very detailed technical assessments in order to reach this judgment at this stage. Of course, there might be circumstances in which we cannot be certain of all of the potential implications of a public authority's conduct, and in such cases, we recognise the greater scope for adopting a proactive approach where the stakes are higher. Finally, we also discuss how we'll be objective and impartial and have regard to the need to be transparent and proportionate through the exercise of our enforcement functions. Please do take a good look through the enforcement policy. We're really looking forward to hearing your thoughts on and your responses to our proposals, and we look forward to engaging with you further. That's it from me for now. I'll hand back to Mike.
Thank you so much, Hattie. Again, a really comprehensive look at the enforcement side of things, and again, broken record, but please do take the time to seek that out and let us know what you think. That brings us to the conclusion of the presentations part of it. And I can see that you have been sending in your questions to us, so thank you ever so much for engaging. And I'm going to bring Natalie back in, the interim CEO, and she will take point on some of the questions and bring others in as and when she needs. So I'll hand over to Natalie.
Thank you, Mike, and I can see that you have asked us some very interesting questions, and I will do my best to answer them. The first one we've got up is around our approach to environmental improvement plans, and quite rightly, in Northern Ireland's case, the environment strategy. So fundamentally, our role is about reviewing and reporting on progress. That sits within our statutory responsibility. But the question here is, can I clarify if the OEP will also have a role in the development of the EIEP to ensure it's fit for purpose in the first place. So the EIPs and the strategies are not part of the OEP's responsibility per se. However, as our thinking is evolving, and this applies as much in England as it will in Northern Ireland, we do have an interest in environmental improvement plans and environmental strategies that demonstrate progress and where progress can easily be measured. We are due to report in England probably in May now in relation to the current EIP in England, and as has been mentioned by Emma, we are developing advice to the Northern Ireland government on the environment strategy in live time as I speak, and fundamental to both of those is our view on what a good environment strategy or EIP should contain. So that is different, of course, from being part of the development of either of those strategies, but nonetheless the OEP will take a position and give a view on what we think an effective environment strategy is. And so that's a little interruption. It's half term where I am.
Yeah, some packages.
Thank you, my darling. Can you just go downstairs?
Sorry.
It's the joy of homeworking. That's my son Patrick making a guest appearance with us today. So I hope that that answers your question. Please do look out for when we publish our 25-year Environment Plan Monitoring Report in England and provide our advice to the Northern Ireland Government in Ireland, where you can see some more of the detail of that approach set out for you. As I've said, both of these are work in progress at the moment. So that is one question. I'm going to jump around a little bit because I'm going to ask my colleague Grant to step in just a moment. I'm just giving the team a little bit of advance warning so that they can bring in Grant. And that's in relation to questions about complaints that have been received while the OEP has been in interim form, and also in relation to historical complaints to the EU Commission and the extremely complicated point on cross-border issues. But I'm going to ask Grant now to just summarise the approach we're taking to the complaints that we have received to date and how we're transitioning them over to the OEP, and then I'll pick up the other 2 points. So hopefully the magic works and I can hand over to Grant to pick up that first point.
Great, thanks very much. Yeah, that's a very good question. It might be helpful for me to provide some background context. So in the immediate period before the formal establishment of the OEP, people were able to submit concerns to the OEP's predecessor organisations, namely the Interim OEP and the Interim Environment Governance Secretariat, with those complainants being advised that the role of the predecessor organisations was to validate and assess complaints, but not to investigate them. Those submitting those complaints were advised that their concerns would be assessed against the criteria outlined in the Environment Bill to determine the potential validity of the complaints. And then once that had been done, there'd almost be a kind of an indication given as to whether or not those complaints were valid, and an explanation that those complaints would subsequently pass to the OEP once operational. So in light of that context, what has happened now is that any complaints that had been lodged with those predecessor organisations have now passed to the established OEP for further consideration. And from the 28th of February, once the OEP is operational in Northern Ireland, we will consider these legacy complaints further to determine whether they are valid under the Act and whether we are able to take, whether we are able or unable to take the matters further. For any complaints that are deemed to be valid, we will undertake a period of assessment in order to reach a decision as to which complaints we could possibly, kind of take to formal investigation, and that decision will be based on our approaches to assessing seriousness and priority as we finalise these under our strategy. So once that assessment period has kind of been undertaken, and we've been able to reach a kind of conclusion about whether or not the complaints can go to a formal investigation or go to enforcement, what we will do at that stage is we'll be writing to those complainants who did submit those legacy complaints to provide them with further explanation as to whatever action we kind of decide to do. So I think that's an explanation about how we will be kind of progressing those legacy complaints. So thanks very much. And I will hand back to Natalie. Thanks.
Thank you, Grant. So I'm going to pick up the slightly more complex questions around legacy EU Commission cases and transboundary issues. And I'm sure all of you will know there isn't a straightforward answer around transboundary issues, and in particular the complications of the protocol in relation to questions of jurisdiction between the EU Commission and the OEP. In terms of legacy Commission complaints, we have engaged directly with the EU Commission, and we have obtained some specific information in relation to legacy cases, and we're likely to be seeking additional information on those cases. But in general, we will apply the same approach to those cases as we would any new complaint that came to us, so they won't be given any particular status going forward. And in relation to the cross-border issues, entirely candidly, and this is an area we haven't yet worked out what our position is. We haven't had the opportunity yet to develop key strategic relationships with organisations in the Republic, and it's an area we know we need to learn. So this is a plea again from us to you. If you can help us get our head around the key primary issues that may be cross-border, particularly in light of the complexities in which we're operating, we are very interested in hearing from you, particularly to help us prioritise our efforts. And I'll note that our remit, which is imminent but still not quite yet in force, means that our ability to make the meaningful investments in stakeholder engagement in Northern Ireland is a little bit behind the curve from where we are in England. We are very keen to make up the distance though as we go. So I'm appreciating that's not a fulsome answer to that question, but it is where we are at the moment. So going back into questions, we've got two questions I think about the Northern Ireland Environment Agency. So first one is, what regulatory role will NIEA have moving forward? To our knowledge, the regulatory role that NIEA has won't change. It'll be an organisation that falls under our remit in the same way that the Environment Agency does in England. It will be an organisation that we will need to develop a relationship with on an ongoing basis, but its remit is not affected by the creation of the OEP's remit. Pick up, and that I think also answers the question from you, Francesca. Well, that's the Environmental Protection Agency in Republic and Ireland, and that I think I've already covered in that this is an area where we still have much work to do to engage with our broader stakeholders, including in the Republic. So just looking at your questions. So Jane, you've got another question about frequency of potential breaches, and I'm going to ask my colleague Hattie to come in just a moment to talk a little bit about this. But this is an area that our proposed enforcement policy deals with specifically. And so I'm going to ask Hattie to just illustrate that a little bit about how we will assess cases in terms of seriousness, including the frequent repeated conduct and those kinds of different cases with different types of characteristics. So Hattie, over to you.
Thanks very much, Natalie. Yes, as Natalie said, our full intention is that through our enforcement work, we should be able to identify and respond to cumulative issues of the kind described in the comment, and very much agree with the thrust of the comment there. As Natalie said, we've sought to reflect this and make this very clear in our enforcement policy, but we really would welcome your views and comments on whether, frankly, on whether we've been clear enough about that. And any particular comments that you might have about the factor-based approach that I mentioned, and if you can foresee that creating any issues in our intention to very much be able to take into account. combined breaches that might happen over, they might be happening over a long period of time, but actually taken together, they really do show that there's some serious issue which needs to be looked at. And I mean, in terms of how we do that, I'll refer back to my colleague Grant's mountain streams and all the tributaries. We need to be a learning and a listening organisation. We need to be taking information from all of the many sources from which it might arrive, and be able to, in a sensible and comprehensive way, make sure that we can categorise it, and that we have some of our colleagues described sort of spidey senses tingling when we note that actually there are issues that are connected, that we need to put in a pot together, and we need to look at them in the round rather than taking them individually. And we do have plans afoot for our intelligence gathering system in that sense. But again, if any organisations have any experience in that sort of thing, in trying to gather together information from lots of different sources and keeping a sort of track of it, then that would also be really helpful to hear. But it's very much our intention that we do that work. Yeah. Thanks.
Thank you, Hattie. And if you've got a particular perspective on this in terms of how we assess seriousness, please do engage with that part of our consultation. We're very open to hearing different perspectives and challenge as to whether we've got the formulation we've proposed right. So please do tell us what you think about that. So I'm going to pick up another question now. Are there any immediate plans to revoke current EU regulations? Are there plans to do a holistic review of all current environmental regulations? What's the time frame? I'm going to ask my colleague Emma to talk a little bit about this in just a moment. But just to set some context, the OEP doesn't have any remit in relation to making decisions upon revocation of EU regulations. That is very much a matter for government, and in line with our strategy, there will be areas, particularly in relation to new lawmaking, which the OEP may well take a specific advisory role, or indeed may undertake a review role. But I'll refer back, the OEP is a very small organisation, and the capacity to undertake a review of all current environmental regulations is beyond our capacity, and it would be challenging, I think, even with the full weight of government. So instead, we intend to be very targeted in our approach, and Emma talked a little bit about our proposal before now. But Emma, I wonder if you've just got any, just to help illustrate a little bit our proposed approach in relation to monitoring environmental law and providing advice on environmental law.
Yes, of course. Thank you. So as Natalie said, changes to the law are the responsibility of DAERA and the Northern Ireland Assembly, but that doesn't mean that if we think there's something to be said, we won't say it, of course. And so, as I mentioned in my presentation, our approach will be built on engagement and influence. And so therefore, how we think our monitoring environmental law reports will work is looking at the implementation of environmental law and where we think things are perhaps examples of good practice or where things aren't working very well. We'll make those in the form of recommendations together with the evidence, and that will include speaking to stakeholders and getting evidence from a wide range of sources, and then putting those in our reports to government where we think there should be proposed changes to environmental law. Also, I touched on our advice function, which is exactly for these purposes, where there are proposed changes to environmental law that have been proposed by the government, and we will give our own independent advice on our views on those proposed changes of environmental law, where perhaps we think things haven't worked well in the past, using our learning from that scrutiny of environmental law to inform better environmental law going forward. So yeah, through our scrutiny and advice functions, this is an area we will be very interested in.
Thank you, Emma. My back. Thank you, Emma. I'll take any opportunity to plug our consultation and I possibly can in this event. And we do set out our proposed approach in our consultation. If you've got a particular interest in what we've suggested we should do, particularly in relation to new law, or the effectiveness of existing law, please do engage with that part of the consultation and tell us what you think. We're very interested to hear from you. So back to some of our questions. We've got one here. In terms of the Northern Ireland Protocol, what status is Northern Ireland now in terms of infraction risk from the EUCJ? I'll be completely candid, I don't know the answer to that question. I'm not going to pretend that I do. I don't know the current status of any of the live cases, or indeed how that interacts directly with the protocol, but it's an area, of course, that we will be keen to learn more about. So apologies on that. I will take it back to the team. Not everyone who is engaged directly on this is with us here today, but we'll take that back and come back to you if we've got anything to add on that. So moving on to our next question, we've got one from Diane. Thank you, Diane. So Diane asks, we understand you haven't had time yet to come to a settled view in terms of location, visibility and accessibility of OEP in Northern Ireland. However, it would be helpful to hear a little more about your emerging thinking, please. I'll be very happy to take that. We had only today an extensive discussion about growing the OEP, about the OEP's organisational design and the specific additional expertise that we believe we need to fulfil our role in Northern Ireland, where those individuals should be located, so whether we'll have staff in Northern Ireland, our hope is that we will, and a question about how we maintain not just visibility but accessibility in Northern Ireland. First of all, I'd like to say that we've recognised that it is extremely important that we are both visible and accessible. We haven't settled on a final position on exactly how we're going to achieve that at the moment. What we are doing is exploring having not necessarily an office, but some dedicated space in Northern Ireland for OEP staff, and that's because our current thinking is not that we will have a Northern Ireland team and an England team. We will have one single OEP team covering all of those different functions that I just talked about, so that in relation to our Northern Ireland work, we can deploy staff with the expertise to do the work that is needed to be done. What that means is that OEP staff may need to be in Northern Ireland, and different OEP staff might need to be in Northern Ireland physically, depending on our work programme. So what we're trying to do at the moment is explore options for how we can make that work effectively, rather than having a fixed core of staff just focused on Northern Ireland. We take the view that that wouldn't be the most efficient approach, nor do we think that it would provide Northern Ireland with the capability and capacity that we think will be needed. What we are doing, though, is exploring, for example, scheduling routine board meetings in Northern Ireland where our board can be in country. We have nominated one of our executive team as a responsible director for Northern Ireland. We're establishing a Northern Ireland working group within the OEP to make sure that we maintain appropriate focus across all of our functions in Northern Ireland, and we will be developing over the coming weeks a more substantial strategy in terms of both visibility and accessibility. But I know that you will tell us if we're not getting it right, and I'm very interested to hear from you as we move forward about how we make sure that we are both visible and accessible. And as I said, if we're not sufficiently one or both of those things, you need to be telling us about it, because we will want to make sure that we are. So I'm moving on to next question from Sue, which is, what is our role in planning a role of local authorities' potentially large impacts on the environment, strategically, especially with regard to building without adequate sewage treatment, where individual applications may be small, but the overall impact can be large. And I think what I would say is I'll bring that back to our working with others about how we prioritise the most strategically significant issues, how we gather cumulative intelligence, and how our activity, particularly in relation to environmental compliance, is driven by our complaints function and the summation of that intelligence. So the OEP doesn't have a specific role in planning per se, but if we look at the issue of planning through the lens of what different functions that we have, you can see that it's engaged. So it is not a simplistic yes or no answer. If the environment strategy for Northern Ireland has a particular pinch point around planning decisions, if planning decisions are being made in a way which contravenes environmental law, if the legal framework itself has flaws in it, needs to be reformed, or where we can identify areas where it's just not working very well, any of these could fall within our programmes of work. What we would want to make sure is that whatever we elect to prioritise is the areas that are the most important and where actually our involvement and our work can make the most difference. And inevitably that will not be all issues. In fact, it might only be a minority. But as I said, I keep coming back to, we won't be able to get it right without your insight and your help. So if there are these key issues which you think are causing real environmental harm or are real barriers to environmental improvement, please bring that intelligence to us and help us understand, because that will allow us to make those prioritisation judgments effectively. So, question from Vivian. So she asks, considering the much smaller size of Northern Ireland versus England, how do you take this into account when prioritising cases to make sure that Northern Ireland cases, which may impact smaller areas, are considered? Will you have a quota to ensure at least some Northern Ireland cases are taken forward? So I think in relation to Northern Ireland, I've already mentioned some of the things that we are doing sort of within the four walls of the OEP in terms of having a nominated lead director for Northern Ireland issues and that cross-cutting multidisciplinary Northern Ireland working group. In substance, though, we will assess cases in Northern Ireland alongside those in England. And you have to remember, for us, cases are not just about the objective size, so the objective size of the potential environmental issues, but also the size of the difference that the OEP can make. We have core duties in Northern Ireland in exactly the same way that we do in England, and if we weren't meeting those minimum duties, we would simply not be doing our work effectively. We see a real opportunity for the OEP to make material difference in Northern Ireland, and we genuinely do. And inevitably we will ensure that it is given sufficient and equal standing in relation to how we assess what we do. But inevitably what that might mean is that in any one year or in even any one part of the year, we may have a much larger focus on one or two issues in Northern Ireland than in England, and that will ebb and flow over time. And we don't have a quota system. We don't think that would be appropriate, but we will need to demonstrate that we are delivering value for money for our funding from Northern Ireland and meeting those statutory duties that we have. So I hope that answers your question. We've got one more, which are, what are your emerging thoughts on how incumbent EU principles such as precautionary principle and polluter pays principle will be approached through the Environment Bill? I think the short answer to that is have a look at the advice we've given to government on the principles policy statement. I think that comprehensively sets out our thinking in relation to that in particular. I don't want to go much further than that. It is a complicated question, but please do have a look at the advice we've given on that, certainly in the English context so far. So, Mike, I think I've answered all of the questions that have come through, but if I have missed anything, if any of the panel would like to flag that up, or indeed if any of the panel want to add any further context, I appreciate that you've heard a lot from me and only a little bit from my team, but Mike, have I missed anything, or is there anything else I need to cover?
Thank you, Natalie, and thank you for doing such a good job on those questions. I think we will have a look through, and if there's anything that we haven't covered off that's been asking the questions, or on reflection there's something we perhaps should have said and didn't, we will have some opportunity to write some of that up and make sure we share it with people through the distribution list for the event. So I'm not aware of anything, nothing's been flagged to me, but we will do a quick exercise just to make sure that we haven't missed anything and that we take opportunity to circulate it if we need to. I think that kind of draws us to a close. I think there was one last thing which we were going to look at just before we let people get on with the rest of their day, and that was just sort of rounding things off by looking at what we want success to look like. I think there's one more slide to go, so I don't think you're off the hook yet, Natalie. I think there's just one more just to close us off, but also I think just to again, thank everybody so much for taking the time to be with us this afternoon. Please do take part in the consultation. So yes, this is a big week for us in terms of getting that remit for Northern Ireland. We've kind of got this in diaries as quickly as we could, but obviously this is the start now of a lot more of that stakeholder engagement and a lot more of that presence from the OEP, because we now have the remit to do it. I'll hand back to Natalie just for that last point.
Thank you, Mike. And I do see that I did miss one question from Francesca about the gas caverns along the Antrim coast. I think it's coast. Hand on heart, I don't know the answer to that question, but I'm going to ask my team to go and look at that and tell me what the answer to that question is. So, Francesca, we may well have to come back to you on that particular point. So, before we wind up, this last bit is about how we're going to measure success. Now, I'm sure you all know the OEP is still very new. Nearly everything we're doing for the first time still, including using this forum, which I think has gone reasonably well so far. I feel like I'm in safe hands. But what that means is that we anticipate that we won't get everything quite right. We'll try our best to do that, but we're on a learning journey with you along with us, I hope. So the strategy we've proposed is to cover this initial phase that we're in. We expect to review it within around 18 months' time to pick up on the learning that we have during that period, and we may well, in fact I anticipate that we will refine it in light of what we've learned during that period. We will continue to engage widely with those that are informed and are affected by our work. You may end up being sick of the sight of us. I hope not, because we have had such fantastic engagement, including from stakeholders in Northern Ireland while we were still in a slightly more tentative jurisdiction than we are now, and we will continue to do that. We fully recognise there is no way that we can do our job effectively without you helping us to get it right. So we are here and we will continue to engage and we will continue to listen. We will, as you might imagine, establish a performance framework to measure our activity, the outcomes and the impacts, and the core of what we're trying to do is to make a difference. It is not what we do, it is what we achieve through our work that matters. We understand that's complex, it's not a straightforward thing, but it is the primary focus of how we're going to assess if we're doing our job effectively, and we will report regularly on this framework in our corporate plan and in our annual reports. And please do keep an eye out for our corporate plan. Our strategy consultation will close, but very quickly after that we will be publishing our corporate plan. And if our strategy sets out how we're going to work, our corporate plan will focus on what we're going to do. So the how and shortly thereafter the what. And through all of that, again, we want to keep hearing from you. One last point, very, very important. I keep talking about engagement, and that's critically important for us. We are busy creating our own Northern Ireland stakeholder contact list, so we're able to contact you directly. However, we can't do that unless we have your details and your agreement to have you in our contacts list. So please do let Ness know if you're happy to be contacted by us in the future for these events or for smaller, more targeted engagement, so that we know who you are and where you are. Personally, I hope that you're keen to stay informed and to keep communicating with us, but please do let Ness know your contact details and that you're happy to be included in our stakeholder database. So I think that is everything. Team, have I forgotten anything? I can see them and they all look stunned, I think.
I think there's one more question.
Okay.
Yeah, so I think we were just about to let everyone go, and we realised there was one question regarding a question about protocol. I'm not sure the detail, but is someone going to be able to just quickly pop back? I think Hattie might be in the frame to pop back in and quickly answer that question for us. Thank you, Hattie.
Hi everyone. Sorry, yes. No, this was just on the very good and slightly complicated question about the Northern Ireland Protocol and the particular risk, infraction risk from the EU, so from the Commission and the Court now. And I think as much as we can say at the moment is that under the terms of the protocol, you're right that the Commission can take action in Northern Ireland against certain EU environmental legislation, which is specifically referred to in the protocol. Now, that isn't all EU environmental legislation. In fact, it's just a small portion to do with trade and, for instance, electricity markets. So it's not all environmental law or EU environmental law by any stretch. Obviously, what we don't know is the approach that the Commission will take or how proactive the Commission will want to be, but there's clearly potential and risk here of duplication between our work and that of the Commission. And so we'll need to make sure that we're in touch with the Commission about this. And this is something that we do recognise in the draft strategy, the sort of the potential residual role for the Commission and the risk of duplication there. But if you've got any further thoughts on it, as with anything else, we'd be really pleased to hear them. Thanks. I'll just pass back to Mike now.
Yes, and I nearly left myself on mute, got through the whole afternoon without leaving myself on mute, and then fell at the final hurdle. Yeah, so that does bring us to the end now. I think we feel we've got all the questions covered, but I always say we will double check. So yes, thank you ever so much. Thank you to all the my colleagues who've spoken and answered your questions. I hope you found that useful. I hope you will feel informed and able to take part in the consultation. I think we're coming up to 4 o'clock, so we can give you a few minutes back, but thank you ever so much for taking part, and we look forward to working with you in the future.